I think now is a good time to loop in Bobby Law here, and let's hear what Bobby has to say about this.
Does anyone remember Fred? The similarities are striking between him and Bobby Law.
The judge was acting like a servant to the people.
Servant.
He recognizes that you know what's going on. They've got people reading what you posted on your video about the lawsuit about their misconduct. Now, there's something we're missing, and they know they're in trouble, and the judge, if he acts improperly in this case, can become a defendant in your federal lawsuit for participating in a malicious prosecution. And he has no immunity if he does not have jurisdiction. That's why I said you always challenge jurisdiction first thing. So we're going to challenge the jurisdiction by demonstrating, first of all, that McMonkey does not have a valid oath of office. It's insufficient, therefore he does not have official capacity. Therefore you could not have been obstructing his official duties. And in the alternative, if you try to say that it is valid, which we'll get a quo warranto to demonstrate that it isn't valid, what we'll do is show that you were engaged in constitutionally protected conduct, and he knew that you were engaged in constitutionally protected conduct. He has seen you before, he knew you were not a threat, and he chose to harass you as a private citizen.
Wow.
And so far,
that would be that they actually, made an effort to consciously entrap you. And if they know that there's, the bond has to work both ways. Unless there's a legitimate reason for them to approach you, they need to stay away. If there's other officers that work in that department, that they could have sent them. But, in your case, let's back up about 3 or 4 steps. One of the original reasons, as I understand, is that you came to Ironton to expose and investigate Blankenship, Evan McKnight, Fouch, and Spoljarek.
that's right.
I think so. That was the reason you originally came down there. So they knew this in advance. And so at the time of your, when you're trying to get the, and I'm reviewing all this stuff that you sent to me, at the time that you went ahead and were at the town hall, the city hall, the reason you were there, as I understand, is you were waiting for connection with the mayor to sign on your permit to do constitutional law class. And he was dodging you. And so you were there waiting for him, maybe thought you were going to catch him coming out the front door, but I guess he left out the back door earlier. And he could have signed that permit at any time. So I wonder why he didn't. Probably because he was afraid that you were going to ask him questions.
Well,
and as public servant, he's got to at least talk to you.
When he came up there, he was a totally different person. He was making sure that you understood your rights. He's like making sure, I'm telling you what, that's why I said these people believe you.
Yeah, well, create an accountability. You're accountable for what you say. So these people, what they've done.
Why don't you tell me, you've got a cell phone here that's being...
Is what they did is that they knew these are the people you're coming to report on as an investigative journalist. You were doing that, and then they stage a situation where they can entrap you and make a bad arrest. Because I understand you've got a federal civil rights lawsuit against them, against the very same officer.
Okay, so the DA is in control of this?
She's also there. So these 4 officers come in.
Okay, the phone is in evidence. Where is evidence at?
It is here at the sheriff's office.
Here at the sheriff's office. Okay, do you have a copy of the warrant that was used to seize the phone?
He jumped into an arrest. In almost every case I've seen in court and in other cases, in cases I've been a party of, those kind of cases.
According to federal law and state law, that he has 2 hours to secure a warrant after he's taken the property without a warrant. And if he hasn't, then it must be returned. Otherwise, you've got a 4th and 14th Amendment violation that's cause for action under Title 42, Section 1983, for all parties who chose to keep the property without lawful authority. So is there somebody in specific you'd like us to talk to? You don't have a warrant. So no warrant was issued. Okay. All right. Who accepts service for the sheriff's department for federal lawsuits? The sheriff himself, or you'll have the sheriff.
We need to link up with the DA because if they don't have a warrant, they can't hold the phone.
No, I know. That's what we're gonna go. She's in court.
The sheriff's in court and the DA's in court. Yeah.
Then I guess we can wait.
How long are they in court? Just without, offending anybody, do you know how long the DA, well, you don't know anything about court, you're just handling the sheriff's office. Okay, ma'am. Can I get your name? Okay, and you have an employee number? Okay. And you regularly work Monday through Friday? Okay. Ma'am, thank you very much and have a nice day. Okay. We'll have it drafted up today and we'll get it filed.
Police could have effected an arrest, and you'd have to have a hearing before your bond could be. This is how, if this is the way I'm assessing it, and it's proper. What these people are doing is they're trying to skirt the law by escaping the obligation of the court to hold a bond hearing, like what they filed motion to amend bond conditions of bond. But they're staging all this. They say, okay, we know that these people are defendants in your federal lawsuit. We know these are the people you came to investigate. We know they're witnesses in the bad arrest. So let's send these same people to where you're at. That's entrapment, and that's since you did not seek them out to do anything, they came in and encircled you by whatever means. Like that's an entrapment, and that won't stand.
Oh,
and
yeah.
on those grounds alone, they would have to deny the state's motion to amend the bond hearing, or not the bond hearing, but to amend the conditions of bond, because they entrap you.
So
that's a 14th Amendment viation, 4th and 14th.
That's definitely a 4th. So let me inform the people of what he's saying. So I received a document with 4 or 5 affidavits. One of the affidavits by the cop is not readable, but the other 3 or 4 are. I can't remember how many there were, Bobby. But
I only saw 2.
I don't know
the
this
ones that you
guy.
sent me, there were 2 that were presented, and one that it looked like it was somehow imprinted on the second one, I think.
Right.
And you can tell but there were only 2 attached to the motion.
Isn't a warrant.
We've only got 2 hours after the seizure of property.
You're talking the wrong person because I'm not.
Anyway, can I get a card from her?
They said the DA said to hold it. This reason why they come.
Yeah, but there's no warrant to hold it, so that's why.
Well, she's not the one making the
Yeah.
decision.
Yeah.
We're gonna have to do it in writing, so I'll draft something up, and I'll have some case law to support it. And if she chooses beyond that to continue to hold it, it's at her own peril. Rights, and we're gonna do this for you, and I'll make sure. He said, he says, well, how would you like to please? And Patrick did well. He said, I just got my papers today, my information, which is a complaint in most states. And he says, I'd like to review this with counsel. And he said, I just need 24 hours. And the judge said, well, how about 30 days? Would that be enough time for you? You come back on February 13th, and we'll go ahead and go from there, because we want to make sure that you are given every opportunity to address this, because we know your rights are involved, and I think he knows that it's constitutionally protected conduct to be video recording in public or photographing in public in a public place, and that the officer overstepped his bounds. So I think what they're doing is giving us an opportunity to file at least a judicial notice or an immediate motion to dismiss, which we will have done. So that's what happened.
Awesome.
Kudos to Patrick. You did awesome, bro.
Yeah.
Okay, my name's Fred, and what I've done is I've been assisting people with legal actions, anything civil or criminal, for the last 10, 11 years. And I do this just kind of to help people. And we've won over 11,000 cases, and we haven't really lost anything yet. And what we do is we help people all the way from simple things all the way up to federal lawsuits, and we don't like to lose. So if your rights are involved, you first of all, and I'm going to say this to all these people since we're live and people are listening. Number one is this: if you're gonna say that it's First Amendment, it's constitutionally protected conduct, you should be able to recite the First Amendment. And it just starts out, the First Amendment is, Congress shall make no establishment of religion or abridge the free exercise thereof, or of the press, or freedom of speech, or.
There you go. You gave them advance notice. They acted upon it to come after you. Hold on a second. My phone's about to go here. Give me 1 minute. I'm going to call you back.
Specific amendment. And you go through all of them, and like the Fourth Amendment. When you're dealing with this auditing situation, you're dealing with the First, the Fourth, and the 14th Amendments. Okay, the Fourth Amendment is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. and no warrant shall issue, which means that if they're going to violate your Fourth Amendment right, they must do so with a valid warrant, not just a warrant. The warrant must be valid, and no warrant shall issue, but upon oath or affirmation, they must swear and attest to the probable cause statement of a crime. Okay, and it must state with particularity the places to be searched and the items or persons to be seized. It's not a general warrant. You can look up Grove versus Ramirez. It's one of the best cases. Another one's Murray versus United States, which is relatively recent. So know what you're talking about, know your rights, and don't get gummed up and mucked up. Don't provoke people. They're people too, but if they're not in their official capacity, they're people. But they keep thinking that they have official capacity all the time, and they don't. So anyway, Patrick's got a great Title 42, Section 1983 lawsuit we drafted up, and I think the judge did today. He's giving Patrick every opportunity to move towards dismissal, because the judge, I can tell by his demeanor, and I've been in hundreds of courtrooms, the judge, you can tell by his demeanor, is saying, this is a hot potato. I want it out of my courtroom, so please do what you have to do to get this out of my effing court. So that's what we're going to do. We'll draft up everything.
We'll get a dismissal.
We'll get a dismissal because, first of all, if the officer, he has an insufficient oath of office, which means he doesn't have official capacity, which we can go over another time. Therefore, he cannot have any official duties being obstructed. And then we can go beyond that. So we're going to work on that and getting Patrick's phone back. So anyway,